Hello, welcome to my talk on an introduction to patenting computer implemented inventions from our series of talks on intellectual property. I'm Scott King, a European and UK patent attorney in the computer technology group here at GJE. GJE is a specialist IP law firm and I'm based in London. So in this final part, I'll discuss IP strategy considerations for computer tech companies. So now we've dispelled some of the myths so that you can see that filing a patent application for a computer implemented invention is possible and viable. And we now have an idea of what is and what is not patentable and where. Let's now look at some strategy considerations to take when considering patent protection for computer tech ideas. And computer tech companies need to think about how their inventions could add value to their company. IP is an asset. And if a patent is filed effectively to the correct innovation, it can be a very powerful tool. And building an IP strategy should be an important element in a company's business plan. All computer tech businesses should be able to show that they've at least considered IP and how it fits with their business objectives. And not all IP strategies are the same, and usually they'll include a number of elements. It's important, however, to take an active decision about how to protect each of your innovations, even if some result in a decision not to file patent applications. Investors will be looking to see that you've considered this. And as I've just said, the decision might actually be not to file patent applications for a piece of software where perhaps the chance of success of obtaining grant is low and no one would be able to reverse engineer the software. Filing a patent application means that you'll have to publish details of the invention, so actually keeping the invention as a trade secret sometimes is the best approach. Innovation capture and IP audits can be part of the process, and it's something that we offer here at GJE, which is time devoted with an IP professional to really discuss your IP strategy and see how it fits with your business objectives. So some considerations that should be taken are shown here. So firstly, patents take a long time to grant. So where do you see your business in 3 to 5 years? Because it might take your patent application that long to get to grant. So do you see your product being around that far in the future? With some products, you may not. So some apps, for instance, may only have a short shelf life. So the question is, patent protection the right approach in this case? On the other side, the patent term is 20 years, and having a broad patent is valuable. So the initial 3 years to get your patent to grant is small compared to the lifetime that you'll have a monopoly right in this area. And it's not all about getting a patent granted. Although that's generally the aim in the end, having a pending patent application can be attractive to an investor or for acquisitions, as they may want to see that the IP has been captured in your products. And it can also build uncertainty in the space for competitors by having applications pending, as your competitors might not know whether your application will grant or not, and it may actually put them off entering into the space. So as we've just seen, some computer implemented inventions are patentable and some are not, and it depends on the purpose of the invention and the effect that it creates. And it's important to identify those that have potential and those that do not, rather than taking an all or nothing approach and filing patent applications for all of your innovations or filing patent applications for none of your innovations. So the drafting of the patent application also matters, and it's critical that you focus on the technical aspects of the invention. Any mention of non-technical, so commercial or business advantages, can kill a patent application. And sometimes inventors get caught up on all the commercial or business advantages that their software provides. And in the area of excluded subject matter, we should be very wary of this, as we don't want to get caught up in an exclusion. So talking about the technical advantages is key, even though they might seem less impressive than the business advantages. So an overview of the pros and cons of filing a patent application against keeping it a trade secret are shown here. So firstly, let's look at the cons. So your idea will become public after 18 months as patent applications are published. So only file patent applications if you're happy for your invention to be published. And there's also always a chance that the patent application may not grant, as not all patent applications are successful. So your idea will have been published and it will be out there for anyone to copy, which would be a problem if your application hasn't granted. However, the pros often outweigh the cons. So patents are a tangible asset. It's a piece of property that has value and can add value to your company. It also looks good to investors and purchasers if you're looking to exit the market quickly. As we discussed, investors may need to see IP before they invest. It can also be used to stop others from working the invention. Patents are a negative right, so they don't allow you to do something, but they do allow you to stop others working your invention. And you can also get revenue from licensing to the big players already in the market. So if you have a really key patent, your business model may actually be not to work the invention yourself, but to license it to other players in the market, as this may be significantly less effort and it may form a revenue stream in itself. So in summary, hopefully I've dispelled some of the myths that you may have heard. It is possible to patent software and computer programs, and the patent protection can be obtained in Europe and the UK in addition to the US. However, the invention needs to be technical, and hopefully now you have a better idea of what is and what is not technical. So thank you for your time. In this talk, I've provided you with an overview of patenting computer implemented inventions and hopefully dispelled some of the myths that are out there. If you'd like to find out more, please watch some of our other talks in this series, and please find details of our website, or feel free to email me if you'd like to contact me, or add me on LinkedIn. Thank you.